I'm here with my colleague Zubair, and in this video we are going to cover off what employment businesses can start to do in light of this new piece of legislation, the joint and several liability legislation that's due to come into force in April 2026. In this video we're also going to cover off the top tips for those businesses. So Zubair, what's your top tip for employment businesses?
Recruitment businesses or employment businesses in the supply chain, they're probably most concerned about this legislation because of where they sit in the supply chain. Mm-hmm. So when you think about joint and several liability, they are the relevant party in most scenarios. They're the ones that will be jointly and severally liable with the purported umbrella company or umbrella company. So it's understandable that, recruitment businesses will be looking at this particular piece of legislation with both eyes open, because ultimately for them, this changes a lot. This changes a lot about the way they operate. This changes a lot about the way they commercially agree their arrangements. And the tips I want to go through really reflect that change. So with that said, I think the very first tip has to be the fact that recruitment businesses need to understand the legislation.
How do you suggest employment businesses go about familiarising themselves with this complex piece of legislation that's got purported umbrella companies, protective anti-avoidance, targeted anti-avoidance?
I think, Sham, the very best thing that they can do right now is to contact Chartergates and book a consultation with us, so we can go through the detail with them, that we can understand their supply chain and then advise them about the ramifications specific to them when it comes to this piece of legislation.
And what's your next top tip?
It's important to follow on from the first top tip, which is to understand the legislation, because my worry when it comes to recruitment businesses is to think that this legislation, or to sleep, I guess, on the purported umbrella company rules. Not understanding the purported umbrella company rules is high risk when it comes to recruitment businesses. So if we have a supply chain in which there are self-employed individuals engaged and supplied, then provided everybody in that supply chain knows that that is the mode of engagement, and provided there's a consistent message throughout the supply chain that the people being supplied are engaged as self-employed, then you've mitigated or at least limited your exposure to being caught by the purported umbrella company rules. So the top tip really here is communication. So once you've understood the legislation, you need to communicate with the rest of the supply chain exactly what is happening. So you need to understand the integrity of the supply chain. You need to know who's in the supply chain. You need to know what the responsibilities of each party within that supply chain is. If you're engaging an umbrella company, you need to ensure that you're happy with their processes, and you need to ensure that the processes that you then have in terms of onboarding, perhaps when you first take on a new candidate, all the way through to when you supply them to the end client, and what that end client might be doing with that operative, what information they might be providing, what policies and procedures they might have which are applicable to that worker.
So are you suggesting that this second tip is almost built up of two separate avenues? One is the communication, which is vitally important.
Yeah.
But also, secondly, the actual employment business understanding their own contractual chains.
Yeah.
So that they know what types of operatives are being provided and how.
Yeah, definitely. I think if we were to break it down in that way, I think, going back to tip number one, which is understand the legislation. Tip number two would then be understand what's happening in your own supply chain. Tip number three would be communication and educating, I guess, other people in the supply chain as well with regard to this legislation, because it impacts everybody. Mm-hmm. It does truly impact everybody. And what's really important is the message that's communicated from the recruitment business down the supply chain and up the supply chain. So provided there is a consistent approach, then they would have limited at least their exposure to the purported umbrella company rules. And I think that's what's really important. I think also when it comes to the purported umbrella company rules, you might find yourself in a situation where you genuinely assumed the individual being supplied was an employee of this umbrella company or this purported umbrella company. And that automatically then triggers joint and several liability. Because if you had assumed they were employees but they weren't, and PAYE should have been operated as a result of it, then we're back to square one. So if you think about those top tips, and you can see almost, you can visualize how you can avoid ending up in that situation. Because if you know the supply chain, you know how they're engaged, you've almost audited that in many respects. You've done your due diligence. You've asked those relevant questions. You've asked to see evidence. By doing all of those things, by shining a light on the supply chain and the specific details about how the person's engaged, but also what documentation might be provided to that individual. We've got, when you're dealing with employment businesses, key information documents and other things like that, for example. And we've seen, mistakes happen where the wrong key information document's been issued, for example. But all of those things could indicate an assumption. All that needs to happen is there needs to be a reasonable supposition that one would assume that the individual was employed by the purported umbrella company. So, when you sort of paint the picture, what we really need to do is iron out any inconsistencies. Iron out any inconsistencies in the supply chain, make sure that message is consistent, make sure everybody knows what they're supposed to be doing, and hope for the best.
Well, that understanding is important, actually, just because you've referred to key information documents, which is obviously part of a different set of regulations that applies to employment businesses. But I guess, again, coming back to the actual supply chain, you've talked about self-employed individuals. As we know, there's deeming provisions that apply to those, and the off-payroll rules apply to limited companies. So do you think that carrying out this almost review or audit of the supply chains will help build processes to ensure, or at least allow parties to have a look at those supply chains and firm up the position in respect of those other provisions as well?
Yeah, 100%. I think this legislation, it's dangerous to look at it in isolation because of how it interacts with Section 44 or IR35. So I think by making sure we are compliant with regard IR35 and Section 44, by just doing that, you've mitigated your exposure when it comes to Chapter 11. Because if you have a problem from a Section 44 perspective, if there is supervision, direction or control, and there is a deeming provision now in play, then under Chapter 11, it's your client now. So it's the recruitment business's client which will be jointly and severally liable for that. And obviously, a client's not going to be happy with a recruitment business if that's what happens. So I think definitely not only reviewing arrangements from a Chapter 11 perspective is important, but using this opportunity now, before April, using this opportunity now to understand the integrity of the supply chain, understanding all of the types of arrangements the recruitment business might have, whether that's PSC arrangements coming through, whether that's self-employed, employed workers. I mean, there's so many different types of engagements out there, to be honest. But understanding what type of supply we have in any particular supply chain is the first step. Because then once you've addressed that, you can really start to tackle the issues. Once you've reviewed all of those arrangements, you can tackle those issues. And prior to April, having your IR35 arrangements looked at, Section 44 arrangements looked at, is going to be key to protecting yourselves from a Chapter 11 viewpoint. So I think that's really important.
Yes, it certainly sounds like probably one of the most important tips for employment businesses. Right, so far we've got understand the legislation.
Yeah.
Familiarise yourself with your own contractual chains, see what's actually there, and communicate those across the supply chain, not just down, but also up to your clients.
Yeah.
What's number 4?
So my fourth top tip then for recruitment business would be that they should treat this new legislation as a new opportunity. And what I mean by that is, I think there's going to be a lot of recruitment businesses which will rely on their past relationships with their existing suppliers. And there might be a false sense of comfort because they already know who they're dealing with, and perhaps nothing in the past has gone wrong. But what they need to remember is there's no statutory defence to joint and several liability. So it doesn't matter that you've known this supplier for so many years. It doesn't matter that they might be your best friend. It's irrelevant. If there's a PAYE liability and there's a shortfall in that PAYE liability, then they can be held jointly and severally liable. So I think don't rely on past relationships. I think this is an opportunity for all recruitment businesses to perhaps refresh their preferred supplier lists. And I think also it's something we've mentioned in a separate video about what kind of checks companies should be doing as part of Chapter 11 and whether payslip checks are enough or not. But I think it's really important here to stress that as the relevant party, so as a recruitment business who might be jointly and severally liable, it's really important that they take control of the checks that they're doing rather than relying on the supplier saying, here's a compliance pack. We've been looked at by X, Y, and Z, and look, all the outcomes are in black and white there, and everything's squeaky clean. I think instead of doing that, it's better for the recruitment business to take control of their own due diligence and understand their own supply chain and audit their own suppliers.
Okay, so I do understand that, and I think as we've known from our experience that recruitment businesses have already started to do some due diligence on their supply chain just because of other tax mechanisms such as the Cattell principle that could impact them. I guess in a lot of ways, recruitment businesses are now far more responsible in terms of carrying out some due diligence on their supply chains. As we know, other parts of the tax legislation, such as VAT and the Cattell principle, can have an impact on recruitment businesses. So they're already fairly well poised to start to do more due diligence or enhance whatever it is that they're currently doing. And so that's actually a great top tip, because it allows businesses almost to just enhance that sort of quite quickly.
Yeah, and I think the Cattell principle, I think that's a good point there, because obviously right now, from a VAT perspective, liability can be shifted unless you can evidence the due diligence you've taken and then the reasonable care that comes with that. And although there's no statutory defence to joint and several liability, it's good to almost treat it in the same way as you would when it comes to the Cattell principle and the due diligence that you would undertake for VAT purposes. In fact, it's probably an extension of that. I think, developing an audit plan or a due diligence plan that would then be carried out regularly on your supply chain is the best approach to mitigating or at least limiting your exposure when it comes to finding yourselves in that situation where there is a purported umbrella company and you have no control over now what happens next.
Okay, so moving on to your last and final top tip.
Okay, so I think this one's probably a bit more commercially sensitive in that I think there are a lot of recruitment businesses who use umbrella companies and have great credit terms with them. And and that's absolutely fine. That's how the market works, and there's no issue with that. Except now that we enter into a new realm of liability when it comes to the joint and several liability rules. Truth is, if you take great credit terms with an umbrella company, and for whatever reason that umbrella company doesn't pay their PAYE liabilities, then you would now be jointly and severally liable. And I think we've seen this plenty of times, to be honest, where umbrella companies offer great credit terms and then end up in cash flow problems and other financial issues and end up defaulting on payments, as a result of which they actually get wound up or they go into voluntary liquidation themselves. In those circumstances, right now, a recruitment business is protected almost because, okay, fine, that company's gone down, it had liabilities, got nothing to do with us. But actually, come April, if that happens, the recruitment business will now find itself jointly and severally liable for any unpaid PAYE. So I think reviewing your contractual terms, reviewing terms and conditions with the umbrella companies that you use is going to be absolutely vital. And I don't mean just the terms and conditions, I mean the payment terms, credit terms, everything really. Like I've said, I think this is the chance to take a fresh perspective on things in terms of your arrangements and how you operate. And I think this is one of those. This is one of those times.
Yeah, I mean, it certainly seems it's almost a fresh start and a fresh set of eyes across the entire supply chain, which, as you say, has got to be managed by those potential parties in the chain that are going to be jointly and severally liable, which at the top of that is most likely going to be an employment business, if there is one in the chain. Okay, so to summarise your top 5 tips for employment businesses, first tip is to familiarise yourself with the legislation.
Yeah.
The next 2 tips almost work in conjunction with each other. That is to know your supply chains, know exactly what's going on in them, and then communicate that across the supply chain. Your fourth tip is to enhance the due diligence that employment businesses should already be doing, and bringing in other aspects of the legislation into that due diligence. And your fifth tip is to review contractual agreements to make sure that they are commercially viable, and that something in those contractual documents, such as extremely favourable credit terms, don't then start to impact you through a joint and several liability aspect.
Sham, have you got a top tip for our viewers?
Well, there is one actually. It's almost building on your commercial tip that you mentioned, and that is that if you have to limit your credit terms with your suppliers, that, as part of the communication aspect of these tips, is to potentially communicate that with the client as well, to perhaps improve your credit terms with them.
The client, yeah, of course.
So money starts to flow through the supply chain, so you're not solely relying on one party at the bottom to find this money somewhere else to pay the liability.
Yeah, and I think on that communication point, actually, really important point, is employment businesses need to have much better lines of communications with the end client, because a lot of the time there are documents, procedures, policies, method statements, if you're looking at construction companies, for example, which actually have elements within those documents which are problematic in terms of, let's just say there's a self-employed person being supplied, but these documents aren't suitable for self-employed. They're drafted for employees, but they're given to everybody on site. It's important to know that, because that could in itself give a rise to a reasonable supposition that, one of the participants in that supply chain thought the individual being supplied is an employee